Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are continuing today with our multiple part series, breaking down the memorandum decision granting in part plaintiff's complaint for permanent injunction. If you have not yet had an opportunity to review our prior episodes, considering the initial 10 pages of this memoranda, please do, because the pages are building one to the next. At the top of page 11, this is continuing from page 10, the court is explaining regarding each set of investigatory records that were identified by the plaintiffs in their complaint. Their interest must be weighed against the public's to determine whether release would constitute an unwarranted invasion of personal privacy, not just a warranted one. Next paragraph states, plaintiff's privacy interest in preventing disclosure of the unaliving images that would impugn the character of the unalived students or plaintiff's memory of them or continue to re-traumatize them, causing extreme emotional distress, outweighs the public's interest in how the investigation was conducted or the scrutiny upon government action. Even the city's action in performing certain redactions supports this conclusion. There is little to be gained by the public in seeing the unalived students and the area around them, the sheets, the spatter, or other depictions. Whereas the dissemination of these images across the internet and in public spheres, where plaintiffs may come upon them by happenstance, as has already occurred, causing them extreme emotional distress, is an unwarranted invasion of personal privacy. The city has blurred certain portions of the investigatory records, but additional redactions are necessary to ensure there is no unwarranted invasion. And if I could interject here, no warranted invasion of personal privacy as to the plaintiffs. And what the court's referring to is that there have been some dissemination, some photographs from inside of Xana's room, specifically where images were blurred. What the court's saying here is that's not enough. More needs to be done. The court continues, the blurring is simply insufficient as it still allows the viewer to see the outline and contours of the students and invites rather than dispels any speculation about how, where, or why they were positioned. The fact remains, the investigation and the criminal case are closed. Releasing these records will have minor effect upon those who continue to be perplexed by facts or fixated on unfounded conspiracies, whereas it has and will continue to have profound effects upon the decedent's loved ones. If I could interject, there cannot be any question, I believe, in anyone's mind that these catastrophic events will have profound effects upon the family members who loved the students, Kaylee, Madison, Xana, and Ethan, who were just so horrifically taken on November 13th, 2022. But in my opinion, the court is not taking into consideration why it is that, as she's putting it here, unfounded conspiracies. It might be unfounded conspiracies in the court's mind, as she signed quite a few orders sealing a lot of this case. This case went on for over 2.5 years, more than any case that I can think of. And also in our last episode of this continuing series, that prominent journalist for the Associated Press, Rebecca Boone, also said she could not think of a case that was this sealed. She's got 25 years, approximately, in the journalistic field. She's based out of Idaho. She has been, according to her declaration, her entire life. I urge you to read it. It was filed when the Media Coalition re-entered this case to try to get these records opened back in July, a motion that was summarily denied by Judge Hippler. I would speculate that the reason why, and I don't think they're conspiracies, I think that they're legitimate questions as to why this case was so sealed, why all the evidence was sealed. So there are a lot of questions, and I think it's because of the unprecedented secrecy of this case. As Ms. Boone herself referred to, this case was closed, as the judge is saying here. The jury trial, where all the evidence was supposed to be presented in a court of law that the public would be able to finally see, was canceled over 3 months ago when Mr. Kohberger pled guilty. And that case is still largely sealed, and it will probably take the better part of 2 more years at the pace that Judge Hippler is going right now, in my opinion, before Judge Hippler will reach those orders that Judge Marshall signed to seal so much of this case, to determine if that information should be unsealed, should remain sealed, or should be sealed with redactions. That's the analysis the court's going through right now. Continuing on with respect to the court's findings here. Judge Marshall writes, the city may disclose the investigatory records in this matter, but must black out any areas within the images, photographs, video, or other media that depict any portion of the students. Continuing on to the next paragraph. Contrarily, the court cannot find plaintiff's privacy interest outweighs the public's interest concerning the dissemination of audio, video, or photographs depicting, number 1, the interior of the bedrooms except as provided above. Number 2, the exterior or interior, including rooms other than the bedrooms of the residents. Number 3, the personal privacy and items of the students found inside the interior and exterior of the residence, including but not limited to containers of alcohol, underwear, ID cards, and other personal items. Number 4, witnesses, including audio of crying. Or 5, statements of witnesses given to law enforcement officials, including statements evidencing their extreme emotions. These are all the things, ladies and gentlemen, that the plaintiffs were also seeking. They were seeking to have a substantial portion of the investigatory files sealed to the public. The court is disagreeing here. The court is siding with the public interest and saying that these things may be disclosed. Continuing on, despite the horrendous nature of this tragic event and its distressing dissemination across the world, the fact remains that it was a quadruple unaliving with investigatory records. These records, much like many law enforcement investigatory records, invade the privacy province of individuals, including suspects, witnesses, victims, and the like. And here, plaintiffs and others unnamed in this lawsuit. However, these records are precisely what the law affords the public to obtain under IPRA, that is the Idaho Public Records Act. Under the law and facts presented, the court cannot find that plaintiff's privacy interest outweighs the public interest regarding these items, such that their release would constitute an unwarranted invasion of personal privacy. Further, releasing images that include alcohol containers, underwear, ID cards, or other personal items of the students may appear embarrassing or reveal speculation as to what may or may not have occurred within the residence, but it does not impugn the character of the decedents, of the students, in a way that constitutes an unwarranted invasion of personal privacy. Therefore, the city shall, upon request and in accordance with its statutory obligation, disclose the investigatory records except as to the students' unalived records noted above or those subject to any other statutory exemption or redaction rule. In the next paragraph, B, the court declares that release of certain images, video, and audio have caused plaintiff to suffer irreparable injury, and there is a reasonable expectation that continued release will cause further irreparable injury, such as permanent injunction is warranted. So now the court is getting to the bottom line. Having discussed this issue already to some extent, now she's going to drive home the point why this permanent injunction is necessary. She begins here as a final remedy. Plaintiff's complaint seeks to permanently restrain the city from releasing the investigatory records described above, pursuant to, and this is the rule of court, IRCP 65. We're going to stop here because this is going to now go into page number 13, which we will address in the next episode of this continuing series regarding this multiple page memorandum decision. But one final point that I would like to point out here is the question remains regarding the redactions that the city of Moscow has made to these records that don't deal with the students that would fall under what the court is saying here. Moscow cannot release as to the unalived students. There's been a lot of other redactions regarding witnesses, regarding other suspects in the crime, and it stands to be seen if the city will find that another exemption exists for future public records requests, or if they will be served unredacted upon a request by the public under the Idaho Public Records Act. This is the statute that is central to this case. If you have any comments, any thoughts, any opinions, please leave them here. And until next time, this is Kathy. Thank you for joining us here today.